Hi, I'm Andrei Mincov, the founder of Trademark Factory, and in this video I'm going to share my thoughts about yet another trademarking screw-up. This time around, it's Pooey Puitton taking Louis Vuitton to court over a trademark dispute. Alright, let me read it from the article and you can find the link in the description below. Louis Vuitton sued by Pooey Puitton, toy maker MGA Entertainment. The parody poop brand tussles with LVMH. Alright, Louis Vuitton, like all major fashion labels, is very willing to get litigious over its protected logos. Los Angeles's MGA Entertainment thinks LVMH-owned house too overprotective. However, Anne has filed a lawsuit against Louis Vuitton. The subject of the lawsuit is MGA's $59.99 Pooey Puitton purse, a plastic case that carries a surprise selection of candy and toys. The Pooey Puitton is painted to resemble Louis Vuitton's iconic collaborative Takashi Murakami handbags, though no reasonable consumer would mistake the Pooey product for a Louis Vuitton handbag, MGA asserts in its complaint. Here's what they say. On or around December 7th, 2018, Louis Vuitton claimed to one of MGA's customers that the Pooey name and the Pooey product infringed upon or diluted one or more of Louis Vuitton's trademarks. The use of the Pooey name and Pooey product in association with a product line of magical unicorn poop is intended to criticize or comment upon the rich and famous, the Louis Vuitton name, the LV marks, and on their conspicuous consumption. I got a few things that I wanted to say. First of all, if you've been following me at all, you would know that I'm a strong opponent of allowing parody as the defense against infringement of copyright or trademark. I believe that if you think it's funny, that's great. But just because you think it's funny doesn't allow you to use other people's property to make fun of them. It's unconscionable for you to make money using other people's property and your only excuse is, well, I think it's funny. As much as I don't like it, I can understand the parody exception to copyright when, sometimes in order to create a derivative work that is completely separate from the original, you may be allowed to do that. But again, I actually wrote a paper on this several years ago. Weird Al asks permission for his parodies. He doesn't have a problem with that. And really, in most cases, it would be okay to ask permission. If what you're doing is a talented parody, in most cases, you would get that permission. And I think the harm of allowing those unauthorized parodies is greater than the harm of some of the parodies never being allowed to exist. But that's copyright. With trademark, there's really no excuse. There's really no excuse to use somebody else's brand, one of their most valuable assets, and just laugh at it. And that's not how trademark law works, and that's why the parody exception to trademarks is almost never accepted. So that's the right thing to do. And Louis Vuitton and all the brands that fight against somebody else trying to take advantage of their fame, of their brands, they're doing everything right. Now, all of this nonsense about laughing, at the expense of the rich is just pathetic. It's a really pathetic. It's too bad that we live in a day and age when instead of admiring somebody's success, admiring not just the success of the brand that create those, 5-figure purses or whatever, it's also the success of those who can't afford it. Instead of looking up and admiring those people, creating parodies and laughing at their expense, it's pathetic and miserable. And that's one thing. The other thing, I just wanted to comment from the trademarking perspective for what's going on here. So it's not that Pooey Puitton is actually suing Louis Vuitton saying that Louis Vuitton is infringing upon Pooey Puitton's trademarks. No, that's not the case. What Pooey Puitton is trying to do, what MGA Entertainment is trying to do, is they want to get a declaratory judgment from the US court that's going to shield MGA Entertainment if the court agrees with them that there is no likelihood of confusion. So what MGA is trying to do is get a US court to say that customers are not likely to be misled into thinking when they're exposed to Pooey Puitton brand, they're not likely to be confused into thinking that they're buying Louis Vuitton product, and that such use is also not likely to dilute the value of Louis Vuitton's brands. If they successfully get that declaratory judgment, that would prevent Louis Vuitton from ever being able to sue them again over this particular Pooey Puitton parody. So this is actually a good strategy. If you know that you may be sued for infringement and you don't agree with that, it's better to go on the offense, seek that declaratory judgment, and if you win, great, you've just won yourself peace of mind. And if you lose, that's still better to do it early on because you haven't made enough money. The damages are going to be, if you even if you have to pay to the other side, you're going to pay less now when you've made just a little bit versus later when you may have made a lot more. So from the legal perspective, that's the right move. From the ethics perspective, from the moral perspective, I think they're completely wrong in trying to, again, rip off a famous brand and make some money doing that. But again, we'll see how that goes. I'm sure that Louis Vuitton is going to defend their right to stop all sorts of rip-offs, whether they're trying to make fun or they're just trying to sell something that's that can mislead people into thinking that they're buying a legitimate Louis Vuitton. We're going to see what they're going to do. We're going to see how far this goes, and you'll hear about it on this channel. Now, if you found this video useful, if you found it interesting, subscribe now, get notified whenever the next video goes live. And if you want to protect your brand, go to trademarkfactory.com and book a call with our strategy advisor, and they'll be able to help you get started. And by the way, we have an internal policy. If you're trying to rip off somebody else's brand and you come to us to help you trademark that, we're not going to do that for you. There is a reason I started this company, and it's to help those who have created something of value protected from being stolen. So if you're the one trying to steal from others, we are not going to represent you. I don't care how much money we may be losing doing this. To me, it's not just about the money. We want to make sure that we're helping those that legitimately want to protect their brand, not steal it from others. Now that's important to me. Now anyway, so if that's you, if you want to protect your brand, great. We may talk soon. And until then, I'll see you in the next video.